My Lord, I come to the second material error, the failure to assess the evidence concerning the department's valuation of phenytoin at £30. As my Lords will undoubtedly know, we deal with this at paragraphs 79 onwards of our principal written submissions. At 79, we make the point that this does more than simply undermine the CMA's cost plus price. It actually is evidence which shows the value that the department attached to the significant patient benefits afforded by phenytoin. And that's what we say in 79. At 80, we refer to the meeting in 2007. We make the not insignificant point that there was material non-disclosure concerning this meeting, either by the CMA or by the department. We've never really got to the bottom of it. In my submission, had this material been disclosed first time round, the first trial may have taken a slightly different tack. But as we shall see in a moment, the tribunal made findings of fact based on the newly disclosed material. And this newly disclosed material showed that the department threatened to price cap phenytoin essentially at £30. And it also showed, by reference to a contemporaneous document, that's at paragraph 81, that it said, "Very many thanks for coming to see us yesterday. We appreciate the effort you have made to help us reach a conclusion which is of value to NHS patients." So we relied, and we'll go to see what the tribunal finds. Just for my Lord's note, as I was reading this over lunch, I noticed that we haven't put a reference to the contemporaneous email we refer to at paragraph 81, and that is at supplemental bundle volume 4. It's at page 1863, tab 78. It says what we've quoted in the submissions.
And just to be clear, it's picking up a point we came across before lunch. You say in your submissions that it afforded value to the NHS. Is that the same as economic value, as we've been talking about it, or is it the same as benefit to NHS or value to NHS patients? Because there was a debate between Lord Justice Zacaroli and you about the difference between something being of benefit to a patient, being of potential value to a patient, being of economic value in the means that we're talking about. Just can we just try and get our terminology straight?
Yes, of course. Sorry,
sort of interloper into this area.
Yeah. First, I'll answer the question, but can I just preface it by saying the Department of Health has never given evidence in this case. It was criticised in the first judgment, and so we've never had the ability to cross-examine any Department of Health person who reached this valuation of £30. So we do not know how the relevant department official who is in charge of generics, if my Lord Justice Green reads the email, he might recognise the name. But we've never got to the bottom of the £30 valuation. Where we say in law it is relevant is that Section 18 is concerned with unfair prices. and what a reasonably willing buyer is prepared to pay. So it's not a ransom price, but a very good indication of the value of a product that is being supplied is what the buyer is reasonably willing to pay, forgetting the cellophane fallacy that my lords know about. And so we rely on this evidence to show that the buyer, the person who bears the economic cost, was reasonably willing to pay £30 for phenytoin. To answer my lord's question about economic value, that we say that £30 valuation reflects the economic value of phenytoin. I would say that the basis for that valuation was that it was giving benefits to NHS patients. And I would also say, I will come on to in the third material error, the department realised that there is significant avoided healthcare costs by prescribing phenytoin. So I answer that by saying, well, in law, it amounts to legitimate evidence because it shows what the buyer is reasonably willing to pay. Why was it reasonably willing to pay that? Well, because it recognised that phenytoin does produce significant patient benefits, and, as we'll come on to in a moment, it recognised, even in those days, that phenytoin brings with it significant avoided healthcare costs.
In your internal disclosure before the CAT and referred to in the decision, within Pfizer, there's a recognition that the Teva price, I think, represents supernormal profits.
Well, again, that's the greatest respect. That's kind of island hopping.
Well,
in the
decision.
Well, in the decision, Mr. Poulton, and I will give, if necessary, I will give the references to it. Mr. Poulton gave evidence in the first trial and was cross-examined by Mr. Hoskins on this. And essentially the point went nowhere. Yes, it is quite clear that if you are, that Pfizer is making material profits on phenytoin. That is the excessive limit. The question is whether it is unfair. We know, Lord Justice Mummery said it's not a law about making excessive profits, it's about whether the price is unfair. And if one has to balance this, so, and I'm going ahead of myself, but if one goes to paragraph 83 of our written submissions, yes, he was cross-examined on competitive profits. What he actually said, and this is his evidence, is that not that Pfizer was making, is that people would think they were making super competitive profits, and therefore there was a concern as to whether they should go down this route, but he didn't admit that the email that the CMA referred to in spades in the decision, and he was cross-examined on, he didn't admit that Pfizer was making super competitive profits. He said that people might say that. What is relevant also is what we say at paragraph 83. Yes, and I'm going to. I need to show you. I don't need to go to the email, but to give it balance, the tribunal finds that Pfizer was entitled to rely, and we'll come on to this in a moment, on the £30 agreed price. It was common knowledge in the industry that the department had intervened, reined in the suppliers, and set, to use the words of the CAT, set the £30 price. And as we see in paragraph 83, Mr. Poulton, who gave evidence for Pfizer, and whose evidence on this point was not challenged, stated that it was widely understood that the department had intervened to require Teva, the sole tablet supplier at the time, to lower its price. He referred to an email he had written on the 3rd of August 2010, when assessing the appropriate level for the revised price. He observed, "This indicates the value of this medicine to the NHS." And the contemporaneous documents, the note is that paragraph 72 of Phenytoin I, the tribunal said he's a straightforward and credible witness, giving answers that are sensible and balanced. But he was cross-examined on that email that you're telling me. But if you just look at the principal written submissions, and then I need to go to the point, you see at paragraph 81, the relevant government official after the meeting says to the supplier, "Very many thanks for coming to see us yesterday. We appreciate the effort you have made to help us reach a conclusion which is of value to NHS patients." Some years later, we have another email within Pfizer saying, "This indicates the value of this medicine to the NHS." Now, in order to just emphasise the importance of the intervention, I know my Lord Justice Green knows Scheme M extremely well, but the regulatory context for the department's intervention was Scheme M. The relevant government official had essentially created Category M and Scheme M. And if I can just give you I'll give you the reference, and it's the Authorities Bundle 4, tab 86.1. It's page 1639, so it's Authorities Bundle 4, tab 86.1, page 1639.13, and the electronic bundle is 1677. But I'll read it and then I'll go to the judgment. So this is Scheme M, and this would be the regulatory context for the department intervening in the price of phenytoin. Now, the Scheme M, paragraph 28 says, "Wherever possible, the department will allow changes in market prices to be influenced by existing market mechanisms. This means that where there is effective competition in respect of any given generic medicine, then the department will not interfere in the operation of the market for that medicine. However, should the department identify any significant events or trends in expenditure that indicate the normal market mechanisms have failed to protect the department from significant increases in expenditure, then the department, and this is important, the department may intervene to ensure that the NHS pays a fair price for the medicine concerned." So when the department intervened in 2007, and we'll see how it did by reference to the findings of fact in the Cat's judgment, it intervened to ensure, I quote, that the NHS pays a fair price for the medicine concerned. And there are several factors in this whole narrative that point to the phenytoin price charged by Pfizer as being fair. So with that, can I go to the judgment on this? Because with the greatest respect to Mr. Holmes, he island hopped the evidence on this, island hopped Greenland size. I mean,
Do you mean Iceland size?
Greenland, huge. And I'm going to explain why. Can I go to the CAT 2? which is a report, you know it is. It starts at paragraph 249, hard copy 857, electronic 932. Now these are the findings of fact that the tribunal makes about this £30 agreement. So we describe a drug tariff in general terms. The drug tariff was published for tablets, used as a proxy. This is, I should say, this is the position of the appellants. For reasons that we will come to, we regard the drug tariff as qualitatively different to other comparators. And by Flynn, we deal with the drug tariff here because as a price set by the department, it is in essence different to the other comparators relied on. Not least because it can be argued, as the appellants did, that the drug tariff says something about the economic value to be attributed to phenytoin sodium. That is not, at least in tablet form, that is not said by the other comparators. And if we look at the footnote there, at the bottom of the footnote, the tribunal states that neither the CMA nor the appellants made anything of the precise manner in which the drug tariff was calculated. In this case, as we will come to, the drug tariff rate for tablets was specifically agreed at a rate of £30. So we then need to see what Pfizer's grounds of appeal were. This was Pfizer's grounds of appeal 1. This was its first ground of appeal. And the tribunal sets out Pfizer's grounds of appeal at paragraph 250. So this is taken from our notice of appeal. Pfizer benchmarked its supply price to Flynn for the phenytoin sodium capsule by reference to the tablet price. It acted reasonably when it did for the following reasons. The phenytoin sodium tablet is a valid product comparator because the drug tariff is the price set by the department and paid to pharmacists for the phenytoin sodium tablet, which is bioequivalent to the phenytoin sodium capsule. No one has disagreed that the tablet and the capsule are essentially the same. B, there is compelling evidence in the case file and elsewhere that it is standard for pharmaceutical companies to benchmark their prices for generic drugs by reference to a discount off the drug tariff. And C, this is the critical point that we were making. In this case, the £30 drug tariff price was set by the department in 2007 and remained at the same level for almost a decade thereafter. It reflected a price agreed between the department and Teva after it had threatened to use its statutory powers to force a reduction in the tablet price in order to achieve value for the NHS. So clearly we're relying on the new material. Pfizer's supply price was set at a 50% discount off the drug tariff price. So the agreed price in 2007 was £30. Pfizer set its supply price to Flynn at 50% of that. And we'll come on to the prices later on. We then, at paragraph 251, at 252, the CAT goes through the Flynn's evidence on this and the CMA's evidence on this. But in order to kind of make the point good, can I go to the top of page 863? EB, I think 938. EB 938.
What's the paragraph?
Well, it's one has to go back several pages to see the paragraph number, but it's paragraph 254, 2, Roman 3. So compare the findings of the tribunal to Pfizer's grounds of appeal, particularly at C and, well, particularly at C. So the tribunal finds as a fact, we are not satisfied that it can properly be said that the department was induced to agree a drug tariff rate that was inconsistent with its public law responsibilities, which is the implication of the decision, that the department was pressured by Teva into agreeing a rate it would not otherwise have agreed. I should just pause there. The CMA at times said we didn't do that. It is quite clear to anybody in the trial that that is exactly what the CMA was arguing. We did not hear from the department, and this is important. Given the price control powers that vest in the state, and given that these powers were threatened in this case, we do not consider the conclusion of the CMA to be warranted by the evidence. The conclusion, essentially, is that no economic value is going to be given for this narrative. We do not consider that it is relevant to make a finding as to what occurred between Teva and the department, or how the drug tariff in the case of tablets came to be agreed. The fact is that the drug tariff underlined was agreed at this rate, and third parties to that rate, i.e. pharmacies and suppliers to pharmacies, including the appellants, were entitled to rely upon it, the former for reimbursement and the latter for pricing information. Yeah. I mentioned three findings of fact from this little Roman 3 and 4. The tribunal found as a fact that the department has set a price of £30 after threatening to price cap Phenytoin. The tribunal found as a fact that Pfizer and Flynn reasonably benchmarked by reference to it. And the tribunal found as a fact that third parties, and that would include other capsule manufacturers, other tablet manufacturers, would have benchmarked by reference to it. If one just goes on to paragraph 2822, that's in the confirmation bias section. I don't want to go through confirmation bias, but it's at page 876 EB 286.
Sorry, the electronic 286.
EB 951, I beg your pardon. 951, hard copy 876. I just want to pick up a finding. So this is paragraph 281 in brackets 2 that there's been some discussion about. But it is the 2/3 of the way down, following debranding. Following debranding, Flynn and Pfizer priced to the tablet price levels, which themselves were informed by the drug tariff rate, which was, we find, properly set by the department. The fact that prices increased is therefore not of itself particularly surprising, and this is on the evidence. It was expected that generic competition would subsequently keep prices under control, so to bring them down. I'm good. So if one goes back to 255, paragraph 255 at 864,
Just while we're there,
yes.
do you have any assistance for me? The point I raised this morning about the next sentence.
Sorry, of 282.
281 sub 2. It's expected that generic competition would subsequently keep prices under control. That did not happen, and it may be that this absence of generic competition is an indicator of competition law infringement in the way that substantial price increases are not. How am I supposed to understand that At the moment, I don't.
I'm not quite sure what it means. I mean, what undoubtedly did happen is that there was competition in the capsule market, there was competition in the tablet market, there was competition in the capsule market. But with the introduction of the new guidelines, it made the position sticky, and the OFT started its investigation very soon after 2012. So that did not happen. It may be that this absence of generic competition is an indication.
If it's a mystery to
Yeah,
everyone,
it's a mystery. It may well.
say so. But
Yeah. But what I would ask the court to note, though, is that the department agreed a valuation at £30, and the way that the generic market works is that competition will bring prices down, and therefore, if it does bring price below the £30, the department will get what the tribunal called consumer surplus. It was reasonably willing to pay £30, and actually, if competition brings prices lower, it gets a much better deal. So if one goes back to 255 on 864, these are all findings of fact. And before we get to 255, I would ask my lords to note a very important point that arose from the submissions of yesterday, which is that Mr. Holmes did not deal with the £30 agreement. And if one looks at the CMA's application for permission to appeal, it does not seek to disturb that finding of fact. Mr. O'Donoghue will deal with this in more detail. What the CMA does is say, well, the drug tariff is not a good indication of price, but it does not grapple with the £30 agreement that was obtained by the department threatening to exercise its statutory powers to price cap.
I think it rather puts the argument the other way, that the CAP doesn't grapple with its own evidence, which runs to 300 paragraphs and 100 pages.
So
I think the CMA says that the CAP doesn't grapple with its own evidence in the decision. So it's not that they may dispute the fact that there are findings of fact. If there are findings, they say they're just not based on a fair reading of the decision, which, as we know, I think is, if you include the section on regulation plus drug traffic,
the CMA may say that.
Pages.
CMA may say that, but it is a flawed submission. Can I take it in stages?
Okay.
If one goes to the top of page 863, which is the paragraph that I've just cited, we are not satisfied that it can properly be said. Little Roman 3 and Little Roman 4. One goes to paragraph 255 under the heading conclusion. We conclude that whilst the drug tariff is not a price comparator, it is a relevant factor that could and should have been considered by the CMA when determining the unfair limit. We also conclude there is no basis for holding that the economic value of the capsules stood at CMA cost plus and no higher. For these reasons, these grounds of appeal succeed. Now, the grounds of appeal we saw in paragraph 250. C, that's why I asked my lords to note paragraph 250C, where we allege that the £30 was agreed and it was obtained by the department threatening to use its powers. That is the finding of fact that the tribunal makes in Little Roman 3 and 4 at page 863, and that is why the Pfizer's first grounds of appeal succeeds. So pausing there, before we get to the decision, pausing there, this is a finding of fact. Mr. Holmes didn't even refer to this yesterday, let alone say that this was irrational. What it is it is said that the £30 drug tariff was not set in conditions of effective competition. One sees this, one looks at, the tribunal looks at what the CMA says in the decision. This is at page 861, paragraph 254, brackets 2. A key reason for the department, and indeed for the CMA and the CMA's economists, to reject this agreed drug tariff price was that it was not set in conditions of effective competition. Well, we know that the supplier was the sole supplier, and we know that the department threatened to price cap that sole supplier. So it is completely wrong to say that the tribunal ignored or did not take account of the reasons that the CMA said this did not matter.
Okay, I think this sort of almost typifies the problem we face.
Correct.
That the CAT says something. It says we take account of X. And when we look at the decision, we find in relation to Teva and its market power, there's something like 40 pages of analysis across about 150 paragraphs. We don't see any reflection of that in the judgment. It just doesn't address it or recognise it or say that this is what... it just comes to this
the greatest respect
conclusion.
That is not true.
Where does it then?
Well, this is a very lengthy judgment. It is a trial, and the tribunal has, on page 861 and 862, given the key reasons why the CMA said that the agreement was not valid and disagrees with it.
But then it agrees with it in paragraph 315. It says exactly the same, comes to the same conclusion as... I mean, this is to be absolutely frank, this is a problem we face with the judgment. One can find... you can find authority for almost every proposition, both black and white.
Well, no, with the greatest respect, no. But in paragraph 315...
2.2. 2.2, subparagraph 2.2, I think it is.
Yeah, but this is... Okay, there is a very...
2.3.
2.2, I mean, 315. There is a very, very important distinction to be made. And this is why I think Mr. Holmes skipped over the findings. This is not, as the tribunal said, just a normal drug tariff rate. The drug tariff rate is applicable all the time. It can be a rate for all sorts of reasons. This was not the normal drug tariff rate. It was specifically agreed by the department. And if one looks at the reasoning of the CMA to reject this agreement, all it says is that, well, I'm ignoring it because it was not set in conditions of effective competition. Well, that, with the greatest respect, is meaningless.
Well, it looks at the progression of price over time when it was a monopoly, a duopoly, an oligopoly, and it looks at the trend in price. So,
but this is
there's a whole variety of different.
This is the
prices,
tablet.
not just 30.
was it reasonable to benchmark by reference to a £30 valuation? The tribunal says it was reasonable for Pfizer to benchmark by reference to this £30 valuation. Forget what happens in the market to the tablet price. Was it reasonable? And in my respect, it is remarkable for a competition authority to say this has no probative value above cost plus. We have the clear evidence saying the department agreed £30, clear evidence finding that it threatened to price cap unless it got £30. You've got the regulatory context which says it will intervene if it's in order to ensure a fair price. And you've got a contemporaneous document that says that this agreement gives value to the NHS. And in my respectful submission, it is remarkable to say that has no probative weight above cost plus.
I have trouble with that for a number of reasons. If the CAT had actually addressed the price movements referred to in the decision, so for example, we know that in 2005 the DT was £3.87, and then it went as high as £113 in 2007, then it moved back. If we had some analysis of that, and that was taken into account, and they came to the conclusion that £30 actually struck a fair balance, then we'd know why they made the criticisms they did. And yet one sees 254 tooth 2, their conclusion that the reason for one of the reasons for its rejection was because the CMA were congenitally ill-disposed towards anything above cost plus. Now, if that's right, then that's plainly relevant. If it's wrong, then they've taken account of an irrelevant consideration. But we'd just have expected to see some analysis of why the CAT came to its conclusion on this really, really important point, because it's superficially an attractive point you make.
Well, it's not. It's compelling. One has a finding by the tribunal at Little Roman 3 that we are not satisfied. It can properly be said that the department was induced to agree a drug tariff rate that was inconsistent with its public law responsibilities. There was no assessment, but everyone knew what the price had been before. The price had gone up, and the department had come in and reined in the supplier. And the department then said, we want a price of £30. Now, why there should be any analysis? As the tribunal said, we did not hear from the DHSC, we did not hear from the department. Pfizer is entitled to take at face value, and did take at face value, because the CAT says it was reasonably entitled to have regard to the £30 agreement for pricing information. It is remarkable to say that this finding has no probative
I understand
weight.
that. I mean, maybe I have in my mind a more forensic point. You can see that somewhere between 3 and 130 odd, 30 is towards the bottom end of that scale. And yet it's just that the CAT doesn't grapple with the evidence, and it comes to a conclusion, and everybody's scrabbling around trying to work out why it's said, or what was the basis upon which.
I'm not sure what evidence the CAT has not grappled with.
300 paragraphs worth. And I know it doesn't have to deal with everything, but would have at least liked to see some explanation why they rejected the analysis in the decision, as opposed to what seems to be very, very broad brush.
I'm mystified as to what the analysis in the decision is. We know that the price of the Teva tablet went up, and we know that the department called them in to obtain the price that it wanted. There is, in my respectful mission, no 300 paragraphs of analysis in the decision which gainsays that. All the CMA does is say this evidence does not prove economic value above cost plus. And if one looks at it from a pharmaceutical company's point of view and looking for a price signal in the market, and you see that the department has agreed a price for £30, and you are told that actually it had got that price by threatening to use its statutory powers to price cap, and then to say that is not of any probative value at all is, in my respectful submission, remarkable.
Can I understand how these different factors fit together?
Yes.
Because there's the finding in the decision, based upon a number of pages of analysis, that the tablet price being charged by competitors, others, was not the result of market, of a workable market. That's one piece of...
Sorry, and just to be absolutely clear, that is not in 2007. That is when we're talking about 2012 onwards. So there are two issues on the tablet price. First, the department's valuation of the tablet in 2007, and that then became the benchmark for the industry. That's the first point. The second point is what happened to the tablet price when competition entered the market. And that's when the CMA says, well, the tablet prices were not the subject of sufficiently workable competition, therefore I'm going to ignore them. Mm-hmm. That's the second point.
So you say we're talking about different time periods?
We're talking absolutely different time periods. The intervention was in 2007. The CMA's analysis of the tablet price when competition entered is essentially 2009, 10, 12, but particularly 2012 onwards.
When you say when competition entered, do you mean when competition entered the tablet
Yes,
market?
yes.
But then that was sort of a fortiori, the position that existed before then. Before then, there was only one supplier. So clearly not workable competition.
Yes.
So throughout the period, the decision, the CMA's decision was, throughout the entire period, the price of tablets was not the result of a workable competition.
That is true,
Yeah.
and I see Mr.
can I
Holmes nodding. However,
You can hear them nodding, actually, it's so vigorous. You can hear them nodding, it is so vigorous.
However, that is irrelevant. So that's why I showed you Scheme M. If the market is not working...
No, I understand what you say about the department and what we should pay, what regard we should pay to its decision to reach a price.
Yes.
But leaving that aside for the moment, the conclusion that the CAT reached in subparagraph 3, on a page I can't identify.
Well, it is, it's 2542, yeah.
The conclusion there, that they don't agree, but they reject the idea that the DHSC was induced to agree a drug tariff rate that was inconsistent with its public law responsibilities. Does that necessarily, you take that as necessarily gainsaying the CMA's conclusion that that price agreement was reached in the context of a market that was not effectively workable competition?
Yeah, absolutely.
You do say it gainsays that.
Yeah, but
so you say the two are the same thing.
It's quite obvious that there was a sole supplier. The sole supplier was increasing the price, and the department, pursuant to Scheme M, said we're paying too much. Called in the supplier, and they agreed a price of £30. Now the question is, and we see this from the CMA in subparagraph 2, it was not a price setting conditions of competition. Well, yes, and the evidence shows that the price continued at the time of the meeting. Teva was the sole monopoly supplier. Yes. It then says reflecting Teva's market power. So the decision is saying, well, Teva got a great price because it was the sole supplier and had market power. And that is what the CAT is disagreeing with at 3. It sets out the CMA's case in 2, and then it says we do not consider the conclusion of the CMA to be warranted by the evidence.
Well, the conclusion it's saying wasn't warranted by the evidence is a conclusion it says the CMA made, which was that the DHSC was induced to agree a drug tariff rate that was inconsistent with its public law responsibilities. Isn't that the
Well, that kind of ties in with what the CMA is saying in the decision in the opposite page of the judgment.
Well, I think you're equating the DHSC acting inconsistent with its public law responsibilities in any case where it agrees a price in circumstances where there is not workable competition and it hasn't done a full investigation to that the CMA might have undertaken. Is that right?
My point is a very, very simple point. If we've seen the medical evidence, hopefully we see that there is a value above cost plus. We now have to look at whether there's any evidence to show the extent of that value. The department agreed £30 for the price of phenytoin. It didn't just, it didn't lie over, it wasn't passive, as the CMA seems to have suggested. It actually threatened to price cap the product. And to say that that valuation of £30 affords no probative evidence is, in my submission, unwarranted, and the tribunal, acting within its jurisdiction, made a finding of fact that this narrative was a factor which showed the value of phenytoin above cost plus.
You probably made the point. Maybe can we just look at precisely what the CAT did find in relation to the DHSS under Section 2? The drug tariff was not a price set in conditions of effective competition.
Sorry.
Yeah.
This is the
paragraph 254 of the judgment.
This is the decision. Yeah.
The judgment.
Yeah. Sorry, the judgment.
Yeah. It is. Yeah.
But the tribunal is
yes.
recording what the decision says.
Then you've got first of all, it says what the decision says.
Yes.
It says, first of all, the CMA concluded that the drug price was the outcome of a competition law infringement. But it doesn't say that, but be that as it may, then we don't accept the CMA's reasoning. The first point is a general point about the DT not being a price at all. I think that's probably agreed by everybody. Then you've got the point about effectively the per se approach to pricing, which, if correct, would mean that this evidence is unlawfully precluded, come what may. Then little 3 and 4, we're not satisfied it can properly be said the DHS was induced to agree inconsistent with public law, which is the implication of the decision. We didn't hear from DHSS, and then we do not consider it relevant to make findings as to what occurred or how the DT in the case of tablets came to be agreed. They treat as relevant the mere fact it was agreed. So they don't seem to think,
well,
they're not really,
there
what
was
are they saying
evidence.
about context?
We didn't hear from the Department of Health. There was evidence that the supplier went in and said 40. Department said no, and there was some, one person left the room, another person left the room, and also the tribunal is not getting into the horse trading between the third. That's what that.
But the only fact they're taking into account is that it was agreed.
Was agreed by threatening to price cap.
Well, they don't say that. But if you want, I mean, maybe I'm being pedantic, but if you want us to stick to what facts.
Well, given the price control power that vests in the state, and given that these powers were threatened in this case, that's little Roman 3. And that's fully consistent with our grounds of appeal. And that's fully consistent with the evidence that was the new documents that were disclosed in the second trial.
Yeah. And what do we make of it at the bottom of subparagraph 3? Which is that the parties were aware when imposing, maintaining their prices. So that I read as a reference to contemporaneous documents, but what the CAT says, third line, we entirely accept that pushback against Pfizer and Flynn's prices is likely to be a factor relevant to unfairly, should be taken into account as a fact indicating that product unit price was unfairly too high. But the fact that such a factor exists or cannot properly be used to exclude from all consideration an independent factor, the drug tariff, that points the other way. What does that mean?
Well, what that means is that, again, this is another, and I'm conscious of the time. I just do need to refer to avoided costs.
Yes.
What this means is that essentially the CMA said we don't think the £30 agreement, the valuation, is probative for the tablet. That was in 2007. CAT disagrees with this. The CMA says when the capsule was launched in 2012, Flynn met the department and the department said it was not happy with the new price. Now, that raises another island of evidence as to whether the department was or was not happy. Because this was another area where we say the CMA was not quite full and frank in the decision. Yesterday, Mr. Holmes said that the department was not happy, and there was pushback. And all that the CAT is saying there is, yes, there was pushback, but it doesn't affect the relevance, the probative value of the £30 agreement. You can't just dismiss that as affording no probative evidence of anything above cost plus.
They certainly say that.
Yeah.
At least here, though, in the retaken decision, they say something else. But do you construe those words in subparagraph 3 as the CAT accepting that there was pushback against Pfizer and Flynn's prices, and that was a factor relevant to unfairness? Well, there was a factor indicating that prices were too high.
There was certain, and again, I can't overestimate this too much. There were certain officials that were not happy with the price increase. We don't necessarily accept there was pushback against Pfizer. This is subheading 3, is Flynn was told by the department. But by reference to the drug tariff was too high. The drug tariff, the department, some officials said the drug tariff was too high, but that was the drug tariff. And that drug tariff reflected the £30 agreement. I think I do need, but I do emphasise that there is no appeal against. So my lord can say that the tribunal does not grapple with it, although it does refer to in the passage that you've shown me on page 862. The tribunal does have on board of the high prices in 2005 and 2006. It's got that on board. It mentions that. It is well aware that the tariff price went sky high, but there is still the evidence that the department valued it at £30 by using its statutory powers. Yeah. Can I quickly go to the third error, which is the failure properly to assess avoided healthcare costs.
Yeah.
This was another very important point in the trial because the value of phenytoin to the department was not just in terms of the medical benefits to the patients, but as an economic cost to the department. And can I go to paragraph 242 on page 847? that is electronic bundle 922. Is that right? Yes. So paragraph 242, this is, you'll see that at the top of the page, you've got to weigh multiple factors. In any case where the excessive limb is satisfied, factors relevant to the unfairness limb need to be identified and weighed. What follows is a list of potential factors for any given case. And then one goes to page 849 and subparagraph 5, that's EB 924. This refers to a relevant factor, and my lords will no, I'm saying it now, that this error, although it's in our principal written submissions and it was in our, it was a big issue in the case, was not mentioned yesterday by Mr. Holmes. So, what is this factor? Cost savings caused by the sale of the focal product exceeding the level of the producer's sublet. So, it will be necessary to consider this factor in greater detail, for counsel will place considerable emphasis on it on behalf of Pfizer. In the context of the capsules, he made 2 points. The price of capsules was less than the human cost of the epileptic seizures avoided. The human costs place less emphasis on this point, but the tribunal says the capsule will deliver an unquantifiable, obviously positive benefit to those patients to whom they're prescribed. And this, the little Roman 2, is, we did emphasise this in spades at the tribunal. The price of capsules was less than the economic cost of epileptic seizures that would otherwise have occurred. Thus, there is the cost to the NHS of treatment of the aftermath of epileptic seizure, which we accept is likely to be far higher than the cost of the capsules that would, on this hypothesis, have caused the seizure to be avoided. The wider cost of the sufferer of epilepsy being off work would also be avoided. But and I probably, to save time, can I go to the principal written submissions? So paragraph 88 of our principal written submissions. That's EB 288. It's 213 of the core bundle.
Yeah, got it.
The recognition by the department that Phenytoin avoids significant to the benefit of the NHS is inextricably linked to the department's agreement in 2007 and thereafter to pay £30. The CAT held that the CMA was wrong to ignore these benefits, but this finding of fact is not challenged in the CMA's application for permission to appeal. It doesn't feature anywhere. The CAT said that the costs were essentially material, they had to be considered. They weren't, and there is no finding, there's no appeal against that finding. In CMA Decision II, the CMA suggested that certain NHS officials in 2012 were not happy about the new Phenytoin capsule price. The decision refers to letters from a small number of officials from the clinical commissioning groups to the department stating that they were unhappy with the price increases because it affected their budgets. At the trial, the CMA called 3 witnesses with fact, Mr. Green, White and Miss Smith, to confirm that they had written to the department objecting to the price increases. However, the CMA was selective in the evidence relied on in the decision. In particular, it ignored the fact that the department, the minister and also the chief pharmaceutical officer wrote back to the clinical commission group correspondence and rejected their complaints. So we get in the decision there was a complaint, that the department was not happy, but we don't get in the decision the responses. And that's quite a material point. We do not see in the decision the responses from the department and the chief pharmaceutical officer. They wrote back and rejected the complaint. The responses from the department made clear that the avoided cost to the NHS of a seizure-free patient outweigh the daily cost of phenytoin to the NHS at the revised supply price. On the 28th of November 2012, the Minister responsible for medicines and pharmacy policy replied to a CCG as follows. And you will see there the department essentially rejecting the complaint about the price increase, and one of the reasons is the potential additional cost to the NHS from adverse reactions if supply is interrupted. So this letter, the site is in footnote 68, shows that the department at the time considered that avoided costs were relevant, and then there were further letters which we refer to in paragraph 90, which equally will not refer to in the decision. So we, at the trial, this is paragraph 90, we cross-examined the three witnesses of fact, Green, White and Smith, and all three
They've
witnesses...
got to be aliases, haven't they?
Like Cluedo.
Be proud.
All three witnesses of fact agreed that the cost of phenytoin had to be balanced with the avoided healthcare costs to the department. The CMAs, and we've got the references to the transcript, but we cross-examined them and they accepted that avoided healthcare costs are relevant to the economic value of a drug. All three factual witnesses in cross-examined articulated the type of avoided costs, the cost of ambulances, A&E, hospitalisation, neurologists, specialist nurses, cost of aftercare. And Ms Smith referred to costs of several £1,000s if someone is admitted to hospital. The CAT accepted this evidence and made findings of fact concerning the avoided costs of the NHS, which the CMA failed to consider. We also cross-examined the CMA's economist on this, and she agreed it would be sensible to undertake the balancing of cost and savings to the department. I should also, and then I will almost finish, we cross-examined Professor Maguire, who was called by the CMA, and he was a health economist. And if one quickly looks at and I'll go to two passages and then I'll finish this, and I'll make two short points on the comparables and then finish. But Professor Maguire was a health economist, and we see him identified at paragraph 47 of the decision, that's 675, and that's EB 715. These were health economists. So Pfizer was trying, well, did adduce evidence, quality evidence, to show that there was a value to phenytoin, that the phenytoin was value for money in 2012. Pfizer adduced Dr. Chris Schedule, and the CMA adduced Professor Alistair Maguire. And if I can just, we've just seen the letter from the department. Can I just go to one document at the supplemental bundle, tab 66. It's tab 66, it's page 1662 of the hard copy bundle, and it's the same for the EB.
This is in a transcript.
This is the transcript. I just would like, it's the internal, it's 131 to 133. But if one just looks at that, one sees the CMA's health economist accepting that avoided healthcare costs are relevant to economic value. Both in relation to the department's letter and both in relation to the QALY evidence.
What's the actual reference within the transcript? What are you looking at? So, all 3 pages?
Yes, it's yes. And that's essentially, I just want to end the avoided costs point there. But the simple point is that these avoided healthcare costs were not taken into account. The CMA calculated a price based on cost plus and accepts that it did not take these avoided healthcare costs into account. And yet its own witnesses in cross-examination, the 3 factual, the economist and the health economist, all accepted that they were relevant to economic value and to the true valuation of phenytoin. And this is a narrative that has simply not been appealed by the CMA in its application for permission. Five minutes on comparables, and then I'll let Mr. Donahue kick off. If one goes to our principal written submissions, if one looks at paragraph 95, you see there the prices of phenytoin at launch in September 2012. So just to distill that paragraph, the drug tariff was £30, the Teva price was £21.35, that's the tablet, Rock Hart price was £24.23, Mill Farm launched at the same time as Flynn, 2012, was £22.63. The Flynn price was £19.84, therefore less when it launched. Flynn priced below the comparable tablet price, and Pfizer's price to Flynn was £13.65. About a year later, those prices, the Flynn price and Pfizer's price, went down by 20% because there was a new capsule supplier. And in my submission, that is highly relevant, given that the £30 was an agreed valuation by the department. It shows that there was starting to be competition in this market, and therefore prices were coming down, and the department was getting a better deal, a better price. But to ignore this evidence on the basis that the prices were not the product of workable competition, which is the basis upon which the CMA rejected it, is wrong. And it's wrong for the reasons that the CAT articulated in liothyronine and this court endorsed in liothyronine. Workable competition is a test, it is not the test. And to say that these prices do not afford any probative value is, in my submission, a mistake. And then lastly, on AEDs, it is even worse. One goes to paragraph 99 onwards of our principal written submissions, and there was a mass of expert evidence relating to the reimbursement costs of other AEDs. And we just set out two graphs there. We go to the second cat at 272, which is page 873. So one only has to look at that graph to see there was a data set.
Sorry, which graph are you in?
Well, I'm looking, for example, at paragraph 101 of our principal written submissions.
Yeah, I've got it, okay.
And the Derek Ridyard was the original economist, and Dr. Schedule put in the table too. This shows that phenytoin was not an outlier when compared to other AEDs. And at paragraph 272, the CMA rejected this evidence as being immaterial to the unfair limb. And the reason it gives, and the tribunal cites it, this is at page 873, EB 948, that the AEDs are not sufficiently similar to capsules to allow for a meaningful comparison. The upshot is that the whole data set, all this pricing data was not regarded as meaningful by the CMA, afforded no probative weight. And in our submission, in our submission, well, it was not afforded any weight, and at paragraph 273, the tribunal disagrees, and it disagrees that the rejection of this data set was irrational and indefensible. And I'll mention 2 points which show that the rejection of this data set was irrational and indefensible. First, the data set in liothyronine that the CAT relied on and this court endorsed, the data set, the inculpatory data set, comprised many completely different drugs. Whereas here, at least, the data set comprised AEDs, drugs to treat epilepsy. The tribunal found as a fact that the AEDs did provide a meaningful comparison, and that is a finding of fact. And just as the CAT, the CMA, the CAT, and this court in liothyronine allowed an inculpatory data set of random different drugs, there is no rationality to disregarding a data set comprising AEDs as not being a meaningful comparator. And the second point that I would emphasize is that the tribunal found as a fact that the importance of the data was that it suggested that the entire market for the AEDs, did not operate on the cost plus basis. And the tribunal said that was fundamental to the inquiry and it cannot be left out of account. It cannot simply be said that these AEDs were not sufficiently similar. Though Mr. Holmes and the CMA make a point about 4 brands, well, that doesn't address the whole data set that Pfizer adduced by any stretch of the imagination, and we deal with the 4 brands issue at paragraph 106 of our principal written submission. But the exclusion of all the comparables, the price comparable data as not affording any probative value of any value above cost plus in our submission is unsustainable for the reasons that the tribunal gave.
Can I just take you back to tablets? Something I wanted to ask you about 268.
268.
So after a 6-week trial, whatever it was, the CAT was not able to decide whether DT prices were relevant or not, and contemplated the possibility they were inculpatory, not exculpatory. What do we deduce from that? We cannot say whether the DT data is supportive of a finding of unfairness or a contraindicator. So they're not precluding the possibility that it's inculpatory or exculpatory, but they can't say.
They can't say.
They don't know.
But what they are saying is that it should not have been left out of account.
And then when they took it into account, they found it to be immaterial when they took the decision.
Well, what one is going back to the decision that should never have been adopted.
I know.
Dominant tablets are now dominant.
Yeah, I know.
I mean, if there was analysis of that, with the greatest respect, analysis just saying dominant, it would be struck down as lacking in any sort of detail. That was simply not.
Yeah.
Sorry, 268 is. Yeah, so 268 is about the tablets.
It is.
Yeah,
Not the DT.
not the DT. No.
Other.
Sorry.
Yeah.
What I just finished, 267.
Yeah.
You see why the tribunal says that they should be taken into account. It's at the bottom, if continuity of supply applied, as per the guidance, then all sellers of tablets are dominant. It goes, yet what we see is something of a fall in prices on the entry of the later tablets, which suggests that continuity of supply was more honoured in the breach. And then there is some competition, but it is certainly suggestive of something that sellers in a similar position to Pfizer and Flynn are selling at similar prices.
Yeah.
And it is suggestive that sellers of a almost identical product is selling at similar prices. I've just showed you. Flynn actually priced below them when it launched.
That was competition intra-tablets, wasn't it? Not between capsules, but I mean, I see the point.
No, but the tablet was a benchmark.
Yes.
Actually, when Flynn launched at £19, it was some £3 below the tablet price, and some £11 below the DT agreed price. So hopefully I've shown the court that there are 5 issues. We say there are 5 material errors: the medical evidence, the £30 agreement, the avoided healthcare costs, the price of tablets, the price of AEDs, and the notion that none of this evidence afforded any extra value in addition to the supply cost price is remarkable. And the tribunal was right to set it aside for these material errors. But Mr. O'Donoghue is going to pick up on that. For the last 10 minutes I've had the gown stuck in the
My lords, I've been doing a lot of recalibration while Mr. Brealey spoke. Without waiving privilege, he told me at 11 o'clock he would need 1 hour. It's proven to be optimistic. I still hope to finish today.
You should have known better from experience.
Oh, yes. Indeed.
And you know that we keep quiet the whole time and never slow anybody down.
Yes, yes. Well, I'm also conscious that Flynn needs a fair crack of the whip as well, so I'll try and rattle through this. with your Lordship's indulgence, I'd hope to address a handful of points. One, the a priori mindset of the CMA in favour of cost plus. That is one of the factors that the CAT criticised in the CMA's reliance on unfair in itself. That's my first topic. I'll then deal more briefly with some of the other factors that also form part of the unfair in itself assessment, which Mr. Holmes touched on. I'll then deal with the health economic evidence, which is technically a respondent's notice point, but fits as an adjunct, at least in practice, to ground two of the CMA's appeal. I'll then deal very briefly with confirmation bias, and if there's time at the end, I want to give your Lordships some further reference to the medical evidence, which was a very, very involved issue at trial. So, well, starting with the a priori cost plus fixation, which I think is technically ground 2A of the CMA's appeal. Now, just to orient this in the decision, as Mr. Holmes showed you yesterday, in the context of Part 1 of Limb 2, unfair in itself, the CMA relied on 6 factors to show the prices were unfair in themselves. And the first factor, which is what I'm addressing on now, is that the prices were substantially in excess of cost plus. Now, we say that the CAT's findings in this regard were entirely justified. And can we look at the evidential basis for the a priori assumption? Because one of the curious features of Mr. Holmes' submissions yesterday is he was very reluctant to show you any of these key passages. The key point is the CMA did have an a priori view or bias that prices in a workably competitive market should be at or close to cost plus. There was a vigorous debate at trial between the economists on this issue. Our expert, Dr. Majumdar, said it was incorrect to suppose that in workably competitive markets, prices would be at cost plus levels. The CMA and its expert disagreed. And having heard the experts on this issue in the teach-in, hot tub, and cross-examination, the CAT found that the CMA's view was wrong. Now, just to give you the evidential basis for this, we can pick this up first in the CMA's own closings at trial. That's in supplemental tab 16, 1159.
You will at some point, I mean, we need to ground this in the judgment.
Yes, well, I'm going to give you compendious reference.
And not just where they say it. What we want to know is why they say it, because we know they say it in lots and lots of different places and lots of different ways.
Yes.
So what we've got to find out is not that they think it, because they plainly do, why.
Yes.
And whether that is justified.
Yes, well,
Which is quite a narrow issue.
I'll develop all of that. But starting with the battle lines, if I can put it that way. So CMA's closings, tab 16 of the supplemental bundle, 1159. So well, this is Annex 3 to their closings, and you see the heading Unfairness.
Just supplementary bundle.
Volume 3, tab 16.
Give me the electronic page again. 116 something.
My lord, it's the same. That's the one of the bundles that is not disrupted. 1159. So the heading's Unfairness, Annex 3, then over the page of paragraph 4, 1160, you'll see paragraph 4. They say, at a conceptual level, Ms. Webster and Mr. Harman, who were the CMA's expert economists at trial, made 3 points about conditions of normal and sufficiently effective competition or workable competition. First, normal and sufficiently effective competition typically produces an outcome in the long run whereby prices tend to converge at a level that is reflective of costs Those costs, including a reasonable rate of return, are reflective of value. And then you see footnote 12, there is a reference to the cross-examination of Ms. Webster, again, CMA's expert economist. So in closings, the CMA was saying that both of its experts supported its view that competitive market prices are at or close to cost-plus levels. And Flynn described these views as the CMA's evangelical premise, and in my submission, they were right to do so. So that's their position in closing. Now, my Lord, to respond to my Lord Justice's question, the CAT, we can pick this up at 194 of the judgment, 805 hard copy, 880 e-bundle. It's 194 and then 195. Paragraphs 194.
Yeah.
Page 805. So in other words, it's quite a long paragraph. So you see at the start of 194, the CMA's position, as articulated in the decision and defended by its expert, was that CMA cost plus was, at least in the long run, the only competitive outcome in a state of real-world competition, and so on. So that is a direct link with the CMA's position in closings, which I've just shown you. And you can read on where they elaborate. And you'll see, for example, under 1941, they set out the cross-examination of Ms. Webster, which is the footnote reference 12 that I showed you in their closings. And there's an interesting phrase in 1941 under the quotation, an article of faith. When it was put to her, you've an a priori view as to price converging to cost in case of non-efficient competition. Her answer was an unequivocal yes. Then 2, Ms. Webster's view reflected the CMA line, and so on. And then if we go over the page, you'd see under 4, the CMA's view of the economic world was challenged by Mr. Breeding closing. Then if you can read over the page. So to your question, you will see it for the basis of the submission. For example, there's a reference to at the races, where they say the cost plus is not necessarily fungible with economic value. A reference to Victor Chandler, Mr. Justice Laddie, essentially making the same point. So there was a wealth of material before the tribunal where we attacked robustly the idea that economic value equals cost plus. So that was the battle line drawn at trial. And then, my lords, 195 is the resolution of this vigorous debate at trial. And they say, we consider that a state of real-world competition will not necessarily produce prices that sit above cost or the level of CMA cost plus, even in the long run. Even though the CMA cost plus is a consistent theme throughout the decision fails to consider the limits of proposition. You then see the quotation from the decision. But the circumstances in which prices above CMA cost plus might not be excessive or unfair are nowhere considered. The decision accepts a dominant enterprise pricing above cost plus, does not commit an object of per se infringement of competition law. Pricing above cost plus is not necessarily abusive. The problem is that neither the decision or the CMA's experts attempted to draw a line between legitimate and illegitimate and produce a surplus. Failing to do so, the CMA adopted an a priori erroneous view of abusive pricing cases. So, my lords, there you have it in black and white. There was an article of faith, an evangelical premise.
Fact, not law.
Yes.
That's what in subparagraph 4.
Yes.
So the CMA, CAT isn't treating it as the CMA having as an article of faith in law, but of fact.
Yes. As
So how does that then affect the analysis in the decision? Unless one says that it was, if you like, part and parcel of the bias. Well, what does it mean in legal terms?
well, it was very simple. If you have an a priori view, an ex ante mindset,
Of fact, not law.
both. Well,
That-
of economic fact, my lord, I think more
Economic
precisely.
fact, not law.
Yes, because this was supported to the hilt by Mr. Harman
I understand
and
that.
Ms. Webster.
Yeah, I've read the evidence.
So the CMA's view emphatically was that workable competition would lead to prices
Yeah.
around cost plus. The CAT's view, having heard in particular detail expert evidence, was that CMA's view was wrong.
Yes.
And in my respectful submission, the court is entitled to ask, what is the error of law that is said to have been committed? Mr. Holmes can't possibly say with a straight face the a priori view or ex ante mindset was not their position. It was the basis on which they closed a trial. And in my respectful submission, not only is there no error of law, but the CMA's position is itself obviously wrong. And as your lordship put to Mr. Holmes yesterday, and to which frankly he had no answer, in Le Paterel, the CPO case, the excessive pricing case, that was a case where the excess above cost plus was very substantial indeed. I think something like 60%.
Between 60 and 70%.
Yes. And the prices were found not to be unfair because of the value the users attached to the BT services in question. And in my submission, it is worth recalling some of the minutiae of Le Paterel, because the factors in that case that justified a substantial excess above cost plus, they were not exactly of seismic or momentous importance.
No.
It was a boring old fixed line copper wire former state monopoly. And one of the things that was of economic value and exculpatory was that people of a certain age obtained comfort in communicating with a UK call centre rather than an offshore call centre. So the dulcet tones of a Scottish woman were of economic value to people of a certain vintage in this jurisdiction. Now, in a sense, this is quite banal and trivial.
Why
but-
economic value?
Yes.
Why? I mean, you might like to hear a Scottish voice, but why is it of economic value?
Well, maybe a simple question of comprehension. Or, I mean,
One of the Petro was interesting in that there was a real effort made to attach quantitative values to particular attributes of the service.
Yes.
And they identified a number of these so-called benefits, and the CAT accepted 2 of them, and they accepted the evidence of the comparable,
and didn't accept some others.
and didn't accept some others.
Yes.
But it was very, very fact-specific.
Yes.
And it may be that they had evidence that there may or may not have been Scottish tones, but there was a value which people were prepared to pay over cost plus for that.
Yes.
So it was very fact specific.
Yes.
And the CAT analysed the facts, addressed itself to it, and worked out
Well,
whether there was
yes.
a reasonable relationship with value.
Yes. Some yes, some no. One of the factors, of course, one of the gives was there was a service to minimise the scope for scam calls.
Yeah.
Now, all the other telephone operators had something similar. I think the upshot was that BT was slightly ahead of the game, or got there first. But the point I'm making is that in some ways these are quite small beer, but they were capable of justifying a very, very substantial excess. But the key point for present purposes is that is a very, very good example of how a banal demand-side factor can justify in law a very, very substantial excess of cost plus. And that's why in my submission...
Well, it wasn't banal. I mean, that's the point.
Well,
It was valued. It was valued, and a value was attributed, and it was found to have a reasonable reflection relationship with price.
one can debate these things. One can question. I mean, if it is being said that people don't like talking to
And
foreigners,
if your point is that the CAT rejected the proposition that over time generic prices will trend down towards cost plus,
emphatically yes.
as a question of fact,
Yes.
okay, let's take that as the starting point.
Yes.
What does that then? How does that then translate into the CAT's conclusion that the CMA applied a per se approach, which meant that they necessarily, inevitably, excluded any other evidence which sought to justify a price above cost plus. That's quite a leap, even from accepting this.
Well, let's take this in stages. So the first stage is that was the CMA's a priori view. We've seen that in black and white. The second stage is that is not only not a legal point, but in my submission, if it were to be elevated to a legal point, it is one that is obviously wrong. So it doesn't get the CMA anywhere. But the critical point, my lord, and I'll come on to this when I deal with confirmation bias, if one has an a priori or ex ante mindset, or an article of faith, or an evangelical premise, that unless prices fit with my cookie cutter approach to competition based on cost plus, I will a priori be suspicious of them or find them somewhat fishy. That is not an objective evaluation of the evidence. You have loaded the dice or stacked the deck against exculpatory evidence that doesn't fit with the cookie cutter. And that is the vice in the CMA's approach. And it was quite revealing yesterday.
If that was true, it would be a vice.
Well, it
is it true?
Well, it is true. Because there was quite a revealing exchange yesterday with Mr. Holmes. So we saw what the CMA was saying in closing in black and white. We have an a priori. That's our case. And we've got Ms. Webster, Mr. Harmon, and so on. When your lordship put to Mr. Holmes yesterday, well, are you saying that for generic pharmaceuticals in general, the cost plus approach should be applied as quick as a flash? No, we wouldn't possibly say that. But the problem for Mr. Holmes, that is exactly what they were saying in spades in 2024. That is the vice, that is the bias, that is a priori, and it is plainly wrong. And in a way, this is trivial, my lords. Most luxury goods bear no relationship to their cost reduction. It's all based on aura. Bottled water is enormously profitable. High-end smartphones are enormously profitable. Closer to home, my lords, many professional service providers enjoy very healthy profit margins, even in highly competitive markets.
Like the bar.
Due to the value of the service they provide to clients. And on your lordship's point, your lordship may remember the frugality with which chambers are typically run. No pink palaces, costs cut to the bone. So one...
You've got to be joking.
One doesn't need to look very long or very far. Well, we've been in humble premises in Essex Street for many, many decades.
Yeah. Okay.
Of questionable structural integrity.
Let's boil this down to its bare essentials. There's no dispute between the parties, at least in this court, that cost plus is not a necessary outcome in a generics pharmaceutical case. It may or may not be.
Well, Mr. Holmes says that now.
No, in this
he
court,
wasn't saying that in 2024.
The expert evidence before the CAT was that over time prices would trend towards cost plus, whatever that might mean.
CMA's expert.
I'm sorry, CMA's expert.
Yes, that was rejected.
Rejected as a proposition of fact.
Yes.
Not treated as a proposition of law.
Well, an obviously wrong proposition.
Yes. CAT then said that there was an approach on the part of the CMA which was a per se approach.
Well, my lord, not quite.
Well, it used,
so the CMA's own words were a priori. I think, I mean, look, this maybe it's semantic. Yeah. In my submission, the correct way to approach this is that it was a priori ex ante. They were not saying it's absolutely per se, come what may.
No, well, that's the point, isn't it? How do you translate, even taking your case as its highest, and I see what you say, how do you translate that into the CAT's approach, which is that if they perceive the CMA as applying a per se approach, which if it's correct, and they apply this to quite a lot of strands of evidence, they cite that as a reason why the CMA rejected that strand of evidence, because by definition, it was a purported justification. No.
Yes.
But, so it's that translation from the CMA's proposition, broad proposition of evidence, or about the way economic markets operate, into the CAT's analysis of the point of law, the per se approach.
Yes, but my lord, it's really quite simple. The CMA's essentially erga omnes approach was
Hang on, can we just sort of try and reduce the amount of Latin that's coming into this and just keep it in words of fairly straightforward
Yes.
English? Because I'm not sure that I fully understand exactly what you mean by, for example, a priori.
Well, these are the CMA courts.
Well, I know they are, but
What they're saying
what do you
is
use? What do you use?
we have an a priori
prejudgment. Is it
in practice?
Is it
Yes.
bias?
In
Is
pra-
it
in practice,
predetermined
yes.
or what?
Well, it's very simple. If you have a template approach of saying, in my universe, I will expect competitive prices in the long run to converge around cost plus. That is an article of faith as to how I expect to see prices in the market. And if that is your a priori, by definition, anything which doesn't fit with that a priori is suspect, or in this case, to be put in the bin. So the deck is stacked against non-cost plus factors by virtue of the a priori. It is as simple as that. And we saw that in black and white.
What's the legal error in that approach? Is it
Is
it a closed mind? Is it not
a closed
objective?
mind.
Is it biased? What is it?
Well, it's that there is a predisposition within the articulation of the
No, it
text.
can't be a predisposition. They can have a predisposition. That's really important, isn't it? You're entitled to have a provisional view. The really important thing is that as you proceed through any procedure, whether it's planning, competition, or anything, you keep an open mind. I mean, judges, we have predispositions when we come in. We've done preparation. You have a view.
Yes. This is very important. This is the crux of it. So it is one thing to say, well, I have read certain things and I've sort of formed certain provisional views. That's one thing. And that may well be wrong. So be it.
Yeah.
But it is quite a different thing to say, I have a generalized test which has an a priori hardwired into it, such that anything that doesn't fit with that generalized test is suspect, out of scope, or be put in the bin. That is a lack of objectivity of things.
Those three things. What's wrong with saying I have come in with a provisional view, such that anything that doesn't fit with it is suspect? If you then examine it, but with an open mind and a willingness to change your mind, what's wrong with that?
Well, because what they're hardwiring into the pricing is that it should converge towards cost plus as a starting assumption.
Yeah. Okay.
And any deviation from that a priori is considered aberrant. That is the problem. And it's really quite a basic point, which is one must start from a position of neutrality, which is that any relevant and material evidence gets put into the sausage machine. What you don't do is stack the deck from the outset and say, well, there's a hierarchy within my set of admissible criteria that favors one type of comparator over another. It is a lack of objectivity, predisposition, predetermination. The test is loaded with a circular outcome.
And I'm going to just take the expression suspect. I agree with my lord, that can't possibly be wrong. You can have a suspect position, but if you're prepared to listen to the evidence and change your mind, that's okay. Out of scope, put in the bin, considered aberrant. Those are predetermination.
Yes.
And those would be unlawful.
Yes. Well, my submission, that is effectively their position. Because you saw from Ms. Webster, it should converge towards cost plus. That is how a competitive market functions. Therefore, if it's not converging towards cost plus, it is not a competitive market. That is the circularity.
Can I just be clear of one thing? Are we now on the fourth? Well, I forget the name of the ground of appeal. Are we now dealing with the bit about
We're now on 2A.
predisposition?
2A. Well, so we're on ground 2A, which is the first of the 6 factors. But it is also my answer to ground 3, which is if you have this a priori, and again,
So far, the discussion's been about ground 3, as I've been following it.
oh no, 2A.
It's the a priori position that everything will trend to cost plus.
It's the first of the 6 factors.
Yeah. But you're right. If that's right, if
Yes.
you're right, then almost by definition, everything else is rejected because it doesn't fit with the model.
Exactly.
And it's, as you've just explained, it's predetermination and therefore it's equivalent to confirmation bias.
Yes, well, to be clear, I'm not saying it's bad faith. I'm not saying there's anything nefarious deliberate. I'm simply saying that the way this test is articulated as an article of faith, there is an inherent predetermination within that test. And that's all I'm saying. But that is sufficient for my purpose.
So we are on confirmation bias.
We're on, well, it's 2A, which then is essentially parasitic with ground 3.
And 4.
Yes. Well, that's the first of the 6 factors. The others I can take very, very briskly. Then I'll move on to the health economics, and then I've effectively addressed your lordships already in ground 3, and then hopefully I can wrap up on the medical evidence quite quickly. So I've done the first of the 6 unfair in itself factors, and in my submission, that also essentially comprises the third factor, the suggestion that the parties exploited their market power, because it's essentially the same point in a slightly different guise. And let me now, with your lordship's permission, wrap up on the other 4 factors. So they fall into 2 categories. One is a set of factors that the CMA claims the CAT did deal with, but wrongly considered irrelevant. The second category is 2 factors that the CMA says the CAT didn't deal with at all. Now, before we get into the weeds on those, my lord, my overarching response to this subground in 2A is that it is irrelevant for the following reason. The 6 factors go to the question of whether the CMA's decision was right to find that the prices were unfair in themselves. The CMA had no positive case in the decision on the second part of Limb 2, which was unfair when compared to comparables. Now, as Mr. Breed has outlined at length, there were a series of fundamental, essentially factual errors found in relation to the second part of Limb 2. In my submission, they are sufficient for Pfizer's purposes. So it doesn't actually matter if I can win on all of the 6 factors in relation to the first part of Limb 2. Because as your lordships found in the first Phenytoin case, the second part of Limb 2 is not entirely disjunctive. It can be exculpatory. It is sufficient for our purposes if we can get home on the second part of Limb 2. But we also say we get home on the first part of Limb 2 for the following reason. Now, starting with the factors that the CMA claims the CAT dealt with, but wrongly considered to be irrelevant, this concerns 2 factors. The first is the 4th factor of the CMA's list, which is the characteristics of phenytoin sodium. And Mr. Breedy essentially took you through the key points here. The decision was essentially disparaging about phenytoin sodium. So all of this is essentially wrapped up in the medical evidence. And if Mr. Breedy is right in relation to the lack of an irrational factor in the CAT's evaluation of medical evidence, then equally we must be right in relation to the criticisms the CMA makes of this 4th factor, because it is essentially the medical evidence repackaged in a different guise. So that is wrapped up in the medical evidence, which of course the CAT did deal with at some length, as I will show you if there is time. So that's the 4th factor. Now the other factor which the CMA claims the CAT found wrongly to be irrelevant is price selectivity, the prices in other European countries. Now, if we can just quickly look at the judgment on this, it's 2282, it's a 836 hard copy, 911 soft copy.
So you said soft copy 911.
911. 911. So well, at 228 we see the 6 factors being dealt with sequentially, and it's 228 2. So, comparative pricing of European jurisdictions. So it says this factor appears to be suggesting, one, that the price mechanisms in highly regulated pharmaceutical markets are the same, such that the price of pharmaceutical products ought to be the same or similar across jurisdictions, and 2, that Pfizer was obliged to price similar across these markets. So far as 1 is concerned, we do not consider that the CMA has adduced any material to support this in the decision. So far as 2 is concerned, we do not consider there is even prima facie competition law for a dominant enterprise to charge differentially from one jurisdiction to another. So, in my submission, a rather obvious point, prices of pharmaceutical products in other countries are either regulated prices or at least affected by regulation. So you need to consider the nature of price regulation before a valid comparison across countries can be made, which the CMA did not do. And I also note parenthetically that the lack of any reconciliation of different regulatory regimes across jurisdictions was also a criticism made by the CAT in the first Phenytoin I judgment. That's at paragraph 402. And yet in the remittal, despite having been criticised on this front, the CMA did nothing to adjust for the differences in pricing regulation. So in relation to this error under Roman 1, there isn't even an appeal, never mind the suggestion of irrationality. Now, the only point Mr. Holmes made yesterday in response to a question by my Lord Justice Green was to claim that the CAT had misunderstood what the decision said about price in other countries, and that the decision was simply making a point about commercial viability. Now, there are 2 responses to that. The first is that is incorrect. In fact, if one looks at the decision, it's at paragraph 2.348. It's at 1069 hard copy, 1144 e-copy. And you will see there that one of the points the CMA makes, it's not about commercial viability. And they say, oh, well, look at these prices in these other jurisdictions. The UK prices or several multiples of these European prices. So it is part of their unfairness case. The disparity itself tells you something. But even on commercial viability, that is basically the CMA's cost plus point in a slightly different guise. You have lower commercially viable prices elsewhere in Europe, so the departure in the United Kingdom from the break-even price based on those jurisdictions is evidence of abuse. But that is wrong for the same reason why an a priori mindset on cost plus is wrong. It's effectively the same point in a slightly different guise. So that is why in my submission, this factor takes the CMA nowhere, and I do reiterate, there isn't in fact an appeal against the CAT's findings in relation to the lack of reconciliation of the different regulatory regimes across these countries, which is a pretty fundamental point.
And I'll just take you back to 614 and 615, where the Commission in the decision identifies Pfizer's argument. Price increases imposed were necessary to ensure continued supply. It's about putting the product back on a fair, sustainable basis. Only way we could maintain the product, bring it to a sustainable level. And then you've got the analysis of that proposition,
Yes.
including footnote 1011, and then the conclusion at 637.
Yes.
Isn't it? Wasn't that the central point about
Well, it was one of them. We're in my submission, we're still entitled to make the point. It is tricky to compare prices across regulated jurisdictions because they may be affected by all kinds of regulatory factors. So we are entitled to make that.
Yeah.
And we're also in my
Cat
submission.
made that in the first judgment.
Yes.
And they said they are relevant, but you've got to be cautious to make sure you're stripping out, as it were,
Indeed.
regress analysing backwards away from the regulatory constraint.
You cannot simply cut and paste.
No.
And nothing was done in the remittal to address that rather obvious point. And on commercial liability, your Lordship's right. There were two strands to this. One is the point your Lordship's picked up. But I am also entitled to make the point in relation to a priori cost plus bias, because it is effectively saying, well, look, you can break even at a cost plus price. Look at these other European countries. That's good enough for you. In my submission, that is an incorrect a priori approach to the question of pricing. So that's my point you raised.
Okay.
Well, then on the two factors that the CMA claims the CAT did not deal with, these are the fifth and sixth factors. The sixth factor in the decision is, they say the CAT did not consider the effect on the end customer and on patient welfare. In my submission, that is plain wrong.
So where are you?
2286.
It's
So
the,
you're back in the judgment,
yes, Lord, it's
not the CMA decision. Sorry.
yes, well, it's the judgment consideration of the six factors in the decision. It's a 244 paragraph, subparagraph 5, 849 hard copy, 94 e-copy. And here the CAT is making Mr. Brealey's avoided costs, other cost savings benefits points. So the CAT did consider the impact on the two customers, the CCGs and Department of Health. And you'll see at the end of that subparagraph, the point is a valid one and it needs to be taken into account. So a relevant and material error on the CMA's part was the failure to take into account the benefit to the Department of Health and clinical commissioning groups of these substantial avoided costs. Then, my lords, at 906, hard copy, 981, soft copy, it's 320 subparagraph 2. I'll just give you the quotation, we don't need to turn it up. They say, they also deliver significant benefit in the form of avoided costs. And well, just to round off this point, there was substantial evidence before the tribunal on the size of these avoided costs. Now, the tribunal does say 320 subparagraph 2, we accept these benefits vastly outweigh the price of capsules. But in terms of the quantification, my lords, if we can go to the supplemental bundle, tab 15, 1021, which is Pfizer's written closings, and there we draw together
Sorry, supplemental bundle.
tab 15, 1021, my lord, that is not affected by the... Yeah. On volume 2, tab 15, 1021 on the bottom right hand corner. And you'll see, my lord, that 224, there was actually quite good empirical information on the relative sizes of cost of capsules versus savings and avoided costs on a European and UK basis. Then 226, this is Mr. Brealey's cross-examination of the CCG witnesses, all of whom, as he said, agreed there would be significant avoided cost savings. You see over the page of 227, several £1,000s. So to my Lord Justice Green's point on the question of are these, was there a basis for the finding of vastly exceeding the price of capsules? In my submission, emphatically, yes. And to pick up the point my Lord Justice Green put to Mr. Brealey before for the lunch break, one of the many problems with the fictional patient test is that if one hypothesizes this fictional, reasonably wealthy consumer, one leaves out of account entirely all of these avoided cost benefits, clinical benefits other than psychological benefits, the drug tariff price, and so on. That is another example where the lens is so narrow that all of these wider benefits, including the policy of the Department of Health and the CCGs, get airbrushed from existence. And that is why we...
I think that's quite a serious point. I mean, there's a lot of public policy that goes into pricing, which if you looked at everything to the benefit with the perspective of a very narrow, subjectively concerned, reasonably well-off consumer,
Yes.
then you exclude a whole load of potentially relevant considerations.
Well, it's downright dangerous because this is a sophisticated, interlocking, water-bred regime,
Yeah.
carefully constructed, and to
Yeah.
airbrush all the stakeholders in the real world, including the people who pay for and regulate the market, and have this made-up consumer who's not quite as rich as Mr. Brealey, but reasonably well off. I mean, it is for the birds, in my respectful submission. And it is a highly dangerous test that quite apart from...
It makes the test of abuse very divorced from general macro pharmaceutical policy. Because you just can't take any of those considerations into for example, research and development defrayment costs.
Yes, or the...
Individuals are not concerned about that.
Yes, or the willingness of the state.
Yeah. Anyway, that's one of the
on
reasons
this.
why we thought there was a procedural issue. We thought at the very least everybody was entitled to have the opportunity to make submissions about that issue to the CAT. I mean,
Yes.
it came out of nowhere.
Yes. I mean, that is also why my respectful submission. I mean, there was an astonishing example of cakeism by Mr. Holmes yesterday. It was something like a three-card trick. He says, well, we accept we're prepared to go along for now with the provisional view that the remade decision was reached by a route which was procedurally unfair, but then he wants to weaponize all of the findings in that unfair remade decision to inure to his benefit for purpose of materiality today. And it really is an astonishing submission that these unfair findings, that they inure to the benefit of the CMA in a context where no one in this court has had the opportunity to understand the submission.
Yeah, I get that.
Never mind.
What they do is they shed light. And when you see inconsistencies, from our perspective, sitting here, we're just left puzzled as to what the CAT really thought. What was it really trying to get at in the first part of the decision, when it was saying things which it criticised the CMA for in part one and then ignored in part two, or was inconsistent? It casts a backwards light upon the first part. I mean, I get the point. I mean, it would be unfair for us to treat as correct what the CAT said in part two, because no one's had a chance to address it. But context, it does. When you see the two things which are just inconsistent, we're thinking, what on earth do we make of this?
Well, look,
I know everyone's in the same situation.
well, let me say
Sometimes
two.
it works for you, sometimes it doesn't.
Let me say two things. In my submission, the consequence of that situation is the setting aside of the remade decision in full. So that is the practical consequence. But one needs to be very, very careful in retrofitting reasoning from the remade decision to the set-aside decision, because the lens in the remade decision, as we've discussed, is completely different. Indeed, it is unreal. And if that is your lens, it is in a way facile to say, well, all these benefits that I found are relevant and material simply don't enter into the equation. It is a completely different form of assessment. That's why my submission, if Mr. Holmes wants to get into materiality discussion, which seems to me actually improper if things set aside, we say, in fact, it doesn't touch on the benefits that were found to be relevant and material in the set-aside decision, because it's a completely different form of analysis where these factors don't even enter into the equation. But I
understand.
don't propose to detain your lordship much longer than that. How
are you doing time-wise?
Well, I may not finish today. I mean, at least speak for myself, if with the court's indulgence, if we could, and I will endeavour to finish in 15 minutes in the morning. I don't know if your lordships would be able to sit a bit earlier tomorrow. I want to give Miss Stratton and Mr. Pascoe a fair crack at it. It's been quite a long day, and at least from my perspective, I would welcome a chance to top and tail a couple of things. I'm in your lordship's hands.
I know, I've got something early, so just give me a second.
Got something early as well.
Just let me check what's on.
We'll do 10:15.
Yeah, I'm sure I can do 10:15. Let me just check what it is.
we've got some pre-court commitments with our other hats on, administrative hats on, but we could do 10:15
Oh, that would be very helpful.
and get started.
Do my level best to finish in 15 minutes. I'm very grateful.
Ms Stratford, Mr Pascoe, how are you placed tomorrow? How much time do you need? Assuming we're going to give CMA some time for a reply.
Well, I think, yes, if we're going by the original calculations, I think we're agreed the CMA would have a little over an hour, up to an hour and a half. An hour and a half.
No, that's not correct. It's 50-50 as the
Yes,
court determined.
absolutely. 50-50.
And we have had so far, I think, six hours.
Well, I can't do the maths on my feet in my head, but others did do it earlier, and I believe
Yes, so
that's
we
what we
were
got to.
working on the basis we would have tomorrow afternoon, or at least a very good portion of it, in which to respond to these points.
My lord, we also know we haven't dealt with penalties yet. I anticipate that can be dealt with very quickly, but it shouldn't be completely overlooked.
No.
On the 50-50 split, if
Well, we're
we're
going to need
behaving
you to
like
work
that,
that out, frankly. We're not going to get involved in your fisticuffs.
we should have had 3 hours and 45 minutes, and we're obviously not going to
That's
have
because
that.
Mr Brealey went on so long.
We will cut our cloth accordingly, but at the same time, so must the CMA. That's my point.
Right, we'll give you from 10 tomorrow. If any of us are running over in our earlier commitments, you may have to hang around for a minute or so, but we will aim to be with you for 10, which gives you a bit of extra time.
Very grateful. Thank you.
And we'll leave it to you to sort out how the division of time goes. I can't promise that we'll shut up. It's difficult.
We understand, my lord.
Very well. 10 o'clock then tomorrow morning.
All right.